Hello and welcome to Financial Quotient, the show that talks about the need for women to take charge of their financial destiny. Over the last couple of episodes, we have focused on smart banking, basic investing principles, and money management ground rules. Today, we touch upon another very important subject: the legal aspects of wealth and personal finance management, the rights and the obligations that we women must keep in mind when it comes to our money. Joining us to help navigate this slightly complex topic is Neha Pathak, Head of Trust and Estate Planning at Motilal Oswal Private Wealth. We also have with us Bijal Ajinkya, Partner at Khaitan Co. Ladies, thank you so much for joining in. Both of you are subject matter experts, and expertise is exactly what we need, because for us women, family, career, managing the house, being a great host, all of that is top of mind, but the law rarely is, which is why it's really important to have you on the show to drive home that message. So, for the benefit of our viewers, I just thought I'll quickly introduce this. We thought we are going to bucket this conversation into 4 different chapters, 4 different important areas that you must consider and take note of. One is the whole concept of nomination. If there is an asset in your name, or if you are making someone a nominee, what does that really mean? And how does that tie in with things like legal heir or a will? Then we talk about loans, debt in the family, whether it's debt that a spouse has taken or any other form of guarantees, and how that may impact the lady in the house or, in fact, the entire family. Then we talk about the 2 big M's, marriage and money, and the kind of legal sort of implications that you must keep in mind over there. And finally, we talk about inheritance and what women, whether it's mothers, whether it's daughters, whether it's sisters, what all of us must remember when it comes to wills and inheritance. So ladies, I want to start first with, your broad observations in your line of work when you look at women, and a lot of these sort of legal issues come up. What has the last sort of 5-6 years told us? Are women generally getting a little more aware, a little smarter? Are they really taking part in some of these very important financial decisions? Neha, you want to kick it off?
Sure. Hi, Surabhi. Thank you for having me over here. I have seen over the years, actually, women are increasingly coming forward and taking interest in the conversation when it comes to nominations, when it comes to financial literacy, be it figuring out their inheritance. They have been coming and taking charge of that. However, there is a very large segment which is there that actually has no idea of what is going on, where patriarch is the one who's running the business, running the show. The woman is just signing papers and not being aware of what's going on, which in case something happens to the patriarch, then they are left flustered, not knowing what to do, how to take it forward, and which can be quite difficult for them. And
Mm.
yeah, so that is quite an interesting side.
No, absolutely. I guess there's a long road ahead. Bijal, let's get in your opening thoughts as well. Why do you think women need to pay a lot of attention and start looking at the fine print here?
No, thank you. So, one, I would definitely feel that women are at the forefront in essentially starting this exercise of really succession planning for the family. Very often, men essentially take it too easy and they do not believe that it is something which is important for them to do. More so often, especially where they are the working member, do not find it important enough to really spend the time. Women, if they do essentially take it carefully and stride the conflict between emotions as well as being fair, to that extent we've seen succession structures which are driven by women being way more successful than otherwise. Very often we would say is that families, be it men or women, really do not have any clue as to what is the difference between a nomination, a joint holding, a trusteeship, and so on and so forth. And it's extremely important, especially for women, given the fact that their life expectancy is way longer. It is important for them to really understand all the baton so that they can really pass it to the next generation. It's
Hmm.
an extremely important topic, and I do believe that it is time for women to really understand the legal nuances so that they can really take a hold of how to really handle family matters.
Oh, yes, absolutely. I think here it'll be great if women just push ahead and lead the men in just greater awareness and more financial literacy. So let's start from the beginning, ladies. Let's start with the first topic at hand, and that is nominations. And sometimes this is the most innocuous thing. Many a times we don't even think, or when our parents are, putting a nominee on that mutual fund form, or, be it any other form of a financial asset or even a physical asset, even if it's property. Sometimes these things are done without too much thought. So let's first understand the legal standing of a nominee or a nomination versus the concept of a legal heir. Neha, please enlighten us.
So, nomination is basically a designation given to a person in a specific asset or a property that upon the death of an individual who's the owner, the property will be represented by this person whose name has been put in as a nominee.
Okay.
Now, this nominee can be changed at any given point of time by the owner. The legal heir, if we talk about a legal heir is a title that is given as per the personal laws. So personal laws for Hindus is Hindu Succession Act, then we have Muslims following the Sharia law, so on, and there is Indian Succession Act. So there are different laws that are there, and they define who the legal heir for an individual is going to be in case the individual is not there anymore. So these two concepts are very different, and nomination is basically given so that the asset is represented in case the owner is not there anymore.
Okay, Neha, I'm listening to your words very carefully, and the word you chose was representative, the representative of the asset. So, does that mean a nominee can be the representative of that asset, but not necessarily its owner? And then we can, probably get into a lot of other issues there.
You're correct there, Surabhi. So I would like to give you an example. If a man passes away over here, if a man passes away, if the man was a Hindu, then his legal heir are his mother, his wife, and his kids in equal proportions. That is as per the Hindu law. However, when we talk about a nominee, if the same man owned a flat, he can have his wife as a nominee. That wife is not the only legal heir. So you see over here, there is a clear demarcation. There are 4 different legal heirs that are there where there's one nomination. So nominee is just the representation that if the man passes away, this woman, his wife, is going to represent him. Remember, she doesn't become the owner of the property.
Got it. And that is how disputes arise, because I might be the nominee in a certain house property or in a big financial asset, but there could be more than one legal heirs, and then they could come in and challenge my nomination. I guess that's the heart of a lot of, unfortunate disputes that we always hear about. Bijal, come in on this concept of nomination. So when should one apply the concept of nomination, which you have to do? Like I said, today you can't have a mutual fund unless you have nominees on that fund paper. So what should one keep in mind? What should women think about when it comes to nominations? Whether nominees they are appointing for their assets, or if they are nominees, for any properties coming in from the family.
Absolutely. Thank you, Surabhi. So I think what is important to note here is that a nomination, as Neha mentioned, is not really the owner, even after the first holder has actually passed away. Important to note that they're only sitting in the position of a trustee to hold the assets till the time the real owner under succession laws is determined and the asset is really passed on. Very often you've seen situations where an apartment, or for that matter, when you're having a demat account or you have a bank account, you will put in the name of the nominee, whoever really comes first to your mind, without there really being any real thinking as to whether this person is supposed to really hold the asset after the demise. Now, what is important and what we generally would tell families is that try and have the nominee to that particular asset and the heir under your will as the same person, in order to really avoid family disputes. Now, though the law is extremely clear that the nominee is not the owner, and it is the person in this under the succession laws, or for that matter whoever is positioned in the will, is the owner of the asset, you just don't want to get into this particular doldrums as to whether or not the owner of the asset actually intended for the asset to go to the nominee,
Right.
or not have a will and it goes under the succession laws. Like, how often would you have a husband essentially have the nomination in society papers as his wife?
Yeah.
And he's very clear that after, I pass, my wife is the one who's supposed to live in the property. And only after her, she actually passes on to the children.
Right.
More often than not, he believes that is enough.
Mm.
However, the succession laws, when they kick in, especially in a situation where there is no will, the property would essentially go to the mother, the wife, as well as the children in a
Right.
situation of being a Hindu, or for that matter, to the wife and the children in all in equal proportions, which may never really be the intent of the
Yes.
holder of the property. So it
Yes.
becomes extremely important for for women to
Hmm.
understand that if at all they are told that nominations have been done in your favor,
Hmm.
to ensure that even the will is reading in a similar fashion.
Oh, absolutely. Now it makes perfect sense. I mean, one of the major reasons why a will is so important, so that intent is stated very clearly and explicitly. Where is the intent, or whom are the assets supposed to really go to from the owner's standpoint? Got that? And we'll talk a lot more about wills and trusts a little later on the show. But I mean, before we talk about other assets, I want to take a step back and talk about liabilities, because in a family, there could be liabilities, there could be loans, the husband could be running a business, there could be, business guarantees that are taken, or personal guarantees that the husband has taken. Could this impact the wife or the children or the daughter adversely in any way? And then what should the women, if that's the case, and what should the women in the family be aware of? What are the questions they need to ask with respect to debt in the family? Neha?
So when we talk about debt in the family, like any other relationship, the one advice which can be given to women is that have an open and honest communication with the family members. That what are the debts? Where has she signed? What papers is she signing? What will be the potential liabilities that will be there? How is she going to be affected if there is any kind of issue? A lot of time people don't have this kind of open question or communication with the family. So according to me, this happens to be one of the crucial aspects. They should know what they are signing. They should know what they are, where are their directors, what is going to be their liabilities, and what are the assets that they are inheriting. That is very important, because if there are any assets which are tainted by any kind of guarantees that have been given by the husband,
Hmm.
those assets can bear risk when they are inherited by the wife.
Yeah, absolutely. But you'll come in on this as well, because as a wife, or as a daughter perhaps, or as a sister, I might not be a co-borrower to a certain loan. I might not even be a guarantor myself. But even without this, what are these other risks that we need to be aware of? And again, what is the checklist here that any lady should keep in mind?
Right. Uh, very interesting question, and often something which is really buried under the blanket because nobody really wants to talk about it. I think the most important point for any women to really know is one, to know the family assets. Do not sign any paper without really reading it. She must really know what she's signing. It's a very social system in India, and very customary for a woman to really sign anything which her father, her husband, her brother, really gives her. Important to know what you are really signing. What are the family assets? If there are joint assets, like let us assume there is an asset which is held between the husband and the wife jointly, like an apartment, which is very common. If the husband has essentially given a personal guarantee for the loans taken by the company itself, and this particular apartment has been given as a security, you could have a situation that if at all a PG is actually triggered, the asset would essentially be sold. The woman will be left on the road without a house. She may not really have to pay the bank off. She may really get that half share, but what is she going to do with that half of that monetary wealth? It may not really be sufficient for her to really get that lifestyle, which she was used to. Another very important point to really note, and this is something which I have often, noticed in families, especially the concept of Sridan. Now, Sridan is a concept wherein it is assets owned or any wealth owned by a woman which she really receives post her marriage. It could be received by anyone, so long as it is categorized as Sridan, it is her own personal assets. if the husband has a liability, this Stridhan asset cannot really be called in for. Now, it sounds extremely very secure, but what is important here to note is that more often than not, this Stridhan, like the jewelry or any other asset which is given to the woman, may not necessarily stand in her name. You may, during a marriage ceremony, hand over, lots of jewelry to her, and to that extent it may still, on the books be held in the name of parents, held in the name of in-laws, or for that matter the husband. Now only Stridhan, which is held in the name of a woman, is as such, secure. If at all it is not held in the name of a woman and it is held in any other family member's name, you would really need to prove by evidence that this is Stridhan, which is not really very easy to prove.
We really need to dive a little deeper and bring out some of these finer nuances. And great you brought this up, because when we come back after this break, we will discuss the two big M's, marriage and money. How can a woman ensure her security and safety even after matrimonial bliss?